Chapter 8, Action of Debt, Sec. 39. History of action. Debt is regarded as the oldest common law action. In its earliest history it was resorted to for the recovery of a specific chattel, or of a certain quantity of a chattel not in its nature specific, or of a certain sum of money. The original idea was not that a person was violating his agreement, but that the debtor was detaining money. At a later period in its history the idea that one was claiming his property was lost sight of, and the feature of the personal obligation made its appearance, the action of detenue being detached from it. In some of the first known writs the sheriff is required to command the defendant to render to the plaintiff so many marks or shillings, which, so the plaintiff says, the defendant owes him and whereof he unjustly deforces him. The creditor is being deforced of his money in like manner as a demandant in a writ of right is deforced of his land. The following is the form of the writ: the king to the sheriff. Command den, that justly and without delay he render unto R. 100 marks which he owes him as he says and from which he complains that he unjustly deforceth him, and unless he shall do it, summon him by good summons that he may be before me or my justices at Westminster within 15 days from the end of Easter to show why he has not done it. The early conception of the writ was that the complainant was asserting a proprietary right. If the defendant was detaining money from the plaintiff he was regarded as unjustly keeping plaintiff out of his property. The action being thus regarded as of a proprietary remedy it was naturally extended to the recovery of specific chattels belonging to the plaintiff and detained by the defendant. This was the form the action took during the reign of Henry II, 1154 to 1189. In its earliest stage, say Pollock and Maitland, 2 and M. 210, the action is thought of as an action whereby a man recovers what belongs to him. The case of the unpaid vendor is not essentially different from that of the lender. He has parted with property and demands a return. It enters no one's head that a promise is the ground of this action. No pleader propounding such an action will think of beginning his count with whereas the plaintiff lent, or sold or leased to the defendant. In short, he will mention some causa dependi and that cause will not be a promise. At this stage of common law procedure there was no form of action for the enforcement of contracts excepting those under seal which were subject to the action of covenant. But covenant was an action pursued for damages for the breach of a contract, and this action would not lie upon a parole contract. It may readily be seen, therefore, that it was quite natural in cases where there was a certain sum of money due upon a contract of lease or of sale, for the complainant to assume the attitude of a proprietor analogous to that of an owner of tangible property. The idea of a contract founded upon a consideration upon which the action could be based had not yet dawned upon the Englishman. When the writ of right came to be employed in this way, any parole contract which culminated in a debt for money loaned, goods sold, or actual benefits received, became binding on the debtor. But it was not regarded as binding because of any contract, but because it was conceived that the plaintiff had a title to the money due him, and was wronged by its detention. The modern doctrine of contract, as resting solely on consideration, was not developed in English jurisprudence for hundreds of years after the origin of the action of debt. There were three different views taken of this action during its history. First, that which has just been given, where the complainant assumed the position of proprietor, akin to an action for the recovery of personal property. Second, when finally the doctrine of consideration was introduced in its earlier form of benefit to the promisor. Third, when a larger view was taken of consideration, and it was expressed in terms to the detriment to the promisee. The idea of proprietorship was wholly inconsistent with the theory of a contractual relationship. Consequently, when the principle of contract developed, the action assumed a double aspect. In the reign of Edward I, 1272 to 1307, there were two forms of writ, one in debet and detenet, the other in the detenet only, developing into two distinct forms of action, one in which the writ of debt in the debet, or in the debet and detenet, was confined to the recovery of money, while the writ of debt in the detenet only was confined to the recovery of specific chattels. The writ for money remained under the name of debt, while the writ for chattels came in course of time to be known as the writ of debt for chattels. The action of debt finally developed into an action for the recovery of a certain sum of money due upon contract. Sec. 40. Debt, Action of defined. The action of debt as finally developed was an action which would lie for the recovery of a certain sum of money due upon a contract, express or implied. The action lies, according to Chitty, to recover money, in a certain sum or capable of being reduced to a certainty, due upon simple contracts, express or implied, whether verbal or written, upon contracts under seal, upon records and statutes, and upon common law and customs. Blackstone says that the legal acceptation of debt is a sum of money due by certain and express agreement, where the quantity is fixed and specific, and does not depend on any subsequent valuation to settle it. The non-payment of these is an injury, for which the proper remedy is, by action of debt, to compel the performance of the contract, and recover the special sum due. Sec. 41. Debt concurrent with a sumpsit. It is a rule that wherever indebitatis assumpsit lies, debt will also lie. It has long been settled that the action of debt and indebitatis assumpsit are concurrent remedies upon all simple contracts where the sum to be recovered is made certain, either by the contract of the parties or by operation of law. Indeed, the action of indebitatis assumpsit only became the common remedy upon such contracts in order to avoid the wager of law allowed upon actions of debt, as the action of debt is now about to supersede the action of indebitatis assumpsit to avoid the operation of the statute of limitations, and c. Sec. 42. Debt lies for what? Debt lies for the recovery of a sum certain, first, on records, as judgments or recognizances, secondly, on specialties, as single bills or bonds, by or against the parties, or their personal representatives, or against heirs or devisees, or upon articles of agreement to pay money, leases, mortgages, thirdly, upon simple contracts, as for services and works, monies, etc., or on bills of exchange, bankers' drafts, promissory notes, by laws, or foreign judgments, or for fines, and amercements. Fourth, it is founded in maleficio, and lies upon acts of the legislature by the parties aggrieved, or common informers. Sec. 43. Debt on implied contract. Example 1. Debt lies upon an implied contract, where the sum is certain. Illustration, H. and S. During lifetime sold 609 acres of land to O. for $1,800, and made a deed with adjacent warranty of title, dated 26th of February, 1805. N, by action of ejectment, recovered the land from O February 19, 1819, and turned him out of possession. S died in 1820, and C and B were appointed his executors. O, having been ejected from the land which he had purchased from H and S, sued the executors of S and H upon the covenant of warranty, recovering $2,101.50 damages. On this judgment the heirs of O sued out assiaphasers against the heirs of S, recovering judgment against them for $2,178, and $19.32 costs. S. C, executor of S, paid $2,225.19, the amount of the judgment and interest, such payment being made out of the personal assets of S's estate. Will an action of debt lie by S's executors against H for contribution for H's share of the judgment paid by the executors of S? Held in Hickman v. Cersei 17 Tennessee 47, 1836. That it would. The amount was considered to be specific and certain by operation of law. As to one half the amount, it is considered as money laid out and expended for the use of Hickman, and the law implies a promise to pay it. No other action than debt, or indebitatus assumpsit, could have been brought, for the contract is not express but implied. Example 2. 4,007 pounds of seed cotton were delivered by Johnson to Collins to be ginned. Johnson made demand for the cotton, which was refused by Collins. Whereupon Johnson commenced action of debt on account against Collins. It was claimed by Collins that debt would not lie in such case to recover the price of the cotton delivered at a gin, upon refusal to pay for or deliver it to Johnson, unless the cotton had been converted by Collins into money. In such case it was contended that Johnson might have waived the tort of conversion, and a sumpsit for money had and received might be maintained. Sec. 44. Debt and assiaphasers will both lie. Though a statute gives a remedy by sire faces, debt may also lie. Example: Barrel sued Simonton in debt on a judgment. Simonton pleaded nil record, nil debit, and payment. On trial, Barrel produced an exemplification of the record, and rested. Simonton produced another copy of the same record, with entries on it, subsequent to the judgment, showing that defendant had been arrested on a capias ad satisfacendum, issued upon the judgment and discharged from such arrests upon an arrangement for the future payment of the debt. Defendant contended that he had sustained his second and third pleas. The court ruled otherwise. Sec. 45. Recovery must be for whole debt claimed. In the 6 Carpenters case, 8 Coke, 147, 1610, the rule was adopted that, in an action of debt, the plaintiff must recover the whole debt he claims, or nothing at all. For the debt is one single cause of action, fixed and determined, and which therefore, if the proof varies from the claim, cannot be looked upon as the same contract whereof performance was sued for. If, therefore, I bring an action of debt for £30, I am not at liberty to prove a debt of £20, and recover a verdict thereon. In Hughes v. Insurance Company 8 Wheat, 294, 1823, the court said, on this subject, the court is satisfied that the law of the action of debt is the same now that it has been for centuries past, that the judgment must be responsive to the writ, and must, therefore, either be given for the whole sum demanded, or exhibit the cause why it is given for a less sum. Sec. 46. Form of declaration in action of debt on note against maker. Court of Common Pleas of Franklin County, of the term of January, in the year of our Lord 1853. The State of Ohio, Franklin County, A. B. Johnson by John Smith, his attorney, complains of Charles Dill, in a plea of debt for that, whereas the defendant, on the 15th day of July, A. D. 1852, made his certain promissory note, in writing, and delivered the same to the plaintiff, and thereby promised to pay to the said plaintiff $500, value received, 2 months after the date thereof, which period hath now elapsed, and by reason of the said sum of $500 being unpaid, an action hath accrued to the plaintiff to demand the same of the defendant. For that, whereas, the defendant, on the 15th day of September, 1852, at Franklin County, Ohio, was indebted to the plaintiff in the sum of $500, for money then and there lent by the plaintiff to the defendant, at his request, to the damage of plaintiff of $500, and therefore he brings this suit,